Gentlemen, thank you for coming this evening. My name is Raymond He. I'm one of the councillors on the AIIA Queensland branch. Can I begin tonight by acknowledging the traditional owners on the land on which we are gathering, the Turrbal and Yagara people, and pay my respects to their elders past, present and emerging, and pay my respects to any Indigenous persons here in the audience or joining us online. Thank you to Holding Redlick for hosting us this evening. It is a particular delight that we welcome Professor Donald Rothwell from the ANU College of Law, who will be speaking to us about some recent activity happening over in The Hague. A little bit about our presenter tonight. Professor Rothwell is a Professor of International Law at the ANU College of Law, where he has been teaching since July 2006. His area of research has a specific focus on the law of the sea, the law of the polar regions, and the implementation of international law within Australia. Professor Rothwell has written voluminously in these areas, over 200 articles, chapters and notes, both here and internationally. He's also authored and co-authored or edited some 28 books, including most recently The Islands and International Law. Today, Professor Rothwell will be speaking to us about three particular cases emanating out of the World Court. Of the 27 pending adversarial cases before the International Court of Justice, three have particularly caught the attention of the world. These are the Ukraine and the Russian Federation, South Africa, Israel, and Nicaragua and Germany. These three cases,
I don't mind if I can't see it.
Which
seems to be
sit alongside the ICJ's ongoing consideration of the Gambia and Myanmar genocide case, which commenced in 2019, are unprecedented. They place the court at the centre of an intense legal, diplomatic and political controversy. Today's presentation will sketch out these three cases, consider some recent developments and Australia's role and interest in these cases. Professor Rothwell has assured me that he's going to try and keep it legal light, so there's not too much legal jargon on there. And on that, I hand you over to Professor Rothwell.
Thank you, Chair, for that introduction. Can I just start by making some preliminary observations? The first is that, as per the Chair's introduction, I'm not a specialist on genocide. I'm not a genocide scholar, but I am certainly someone who has followed very closely the work of the International Court of Justice. As that's my first observation, and I guess associated with that, I wish to acknowledge that any discussion of genocide, genocide in the context of Israel, particularly sensitive. I acknowledge that and will seek to speak about those issues in an appropriate professional way. Secondly, as the Chair indicated, I'm not intending to do a heavy focused presentation, particularly international law questions. I'm happy to answer those in the Q&A. Thirdly, the Chair neglected to mention that I'm actually a graduate of the University of Queensland, and so to that end, I'm glad to be back in Queensland, and I can assure you it's a lot warmer here than it is in Canberra. On the 31st of December 2023, I had a rather remarkable flight from Vancouver to Sydney. It wasn't remarkable because it was 12 hours late. Thank you, Qantas. It was remarkable because 12 hours before I boarded that flight, I became aware of the fact that South Africa had commenced proceedings in the International Court of Justice against Israel, alleging that Israel was committing acts of genocide in Gaza. And I was fortunate enough to be able to log on to the ICJ's website, download the South African application, and I spent part of that flight over the Pacific reading the South African application before the court, which was an 80-page application identifying and alleging various causes of conduct on the part of Israel, various breaches of international law, and seeking various remedies, including provisional measures. I was struck by significance. I was struck by the detail of the evidence and I immediately got the sense that the next few weeks would be very tumultuous with respect to international affairs and ultimately for the international law. And that has proven to be the case, and that brings me to a degree to what I'm going to be speaking about before you this evening. So in terms of my presentation this evening, I want to speak about three things. The first is a general background to the Genocide Convention and the International Court of Justice. Secondly, I want to speak to you briefly about the three current cases that are before the International Court, which all raise aspects of the Genocide Convention. And then thirdly, I want to make some concluding observations. So first of all, let's start with the Genocide Convention from 1948. The convention, of course, was concluded in the aftermath of the Second World War. But be mindful of the fact that this was a brand new international crime that had been recognised. There'd been a lot of debate and discussion about the conduct of Nazi Germany during World War II, but genocide did not exist as an international crime. There was no recognised convention at the time. So to that end, this is a pivotal moment in terms of post-World War II responses to the events that occurred at that particular point in time. The convention defines genocide. It seeks to prohibit acts of genocide, and it also creates obligations on the part of states to punish genocide, which means that states that are party to the Genocide Convention need to reflect that in terms of their own domestic criminal law to actually punish persons who are alleged to have committed genocide. And to that end, and most importantly for the purposes of this evening's presentation, the Genocide Convention rather uniquely gives to the International Court of Justice compulsory jurisdiction with respect to any disputes that may arise under the Genocide Convention with respect to its interpretation or application. So in terms of a very brief survey of cases that have come before the International Court of Justice concerning the Genocide Convention, you'll see that rather early on there was a very technical case involving a treaty law question, which was one of the earliest advisory opinions that the International Court of Justice was asked to look at in 1951. And then we moved to substantive cases concerning allegations of whether or not states had engaged in genocidal conduct, really arising from the breakup of the former Yugoslavia. You have the Bosnian genocide case from 2007, and you have the related Croatia-Serbia case from 2015. Particularly note the length of time that it took for those cases to work through the International Court of Justice before there was a final determination on the merits. 14 years in the case of the Bosnian genocide case and 16 years in the Croatian case. And then we move to current genocide cases, if you like. And whilst I'm not really intending to talk about the Gambia-Myanmar case this evening, it really is a significant part of the story of understanding where the International Court is going to in terms of looking at genocide matters at the moment. And perhaps most importantly, if you think about the states involved in those earlier cases, your attention will immediately be drawn to why is the Gambia bringing proceedings against Myanmar with respect to genocide. And that immediately triggers questions of jurisdiction, and the one in which a state party to the Genocide Convention, asserting that there's a breach of the Genocide Convention, is seeking to rely upon the Genocide Convention to found jurisdiction in a case before the International Court of Justice. So we see similar dimensions in some of the cases that I particularly want to speak about this evening. So that's sort of the background in terms of the ICJ and genocide cases more generally. So these are the three cases that I'm going to be speaking about this evening, two of them in some detail, one less so. Ukraine, Russia, 2002, obviously arising from the Russian military intervention and invasion in Ukraine. South Africa, Israel, dealing with the events that I've already spoken about. And Nicaragua, Germany, perhaps the lowest profile of the three relevant cases, which also arises out of the Israeli conduct of military operations in Gaza. Now, some preliminary observations about those three cases are as follows. They are all at very early preliminary phases. And so we are many years away from a final determination of these cases on what the International Court would say a merits decision, a final judgment of the court. But rather, all three of the cases are ones which are what are at provisional measures phases. If you like, at a domestic level, we might think about that as a form of injunction, where applications have been brought before the court in which the court is being ordered to effectively order the equivalent of a domestic injunction against the respondent states with respect to alleged breaches of international law as a result of their conduct. So all of the cases are at very early phases, but all of the cases are ones in which provisional measures have been sought, and that is not ordinarily the case. Provisional measures are not often sought in proceedings before the International Court of Justice, and yet we've seen that occur in all three of these cases. The other relevance of this evening's presentation, in addition to the fact that they all deal with genocide, is that they are matters that have all been determined in some way over the last few months. So in summary, in terms of the common characteristics between these three cases, as I've already said, they all rely upon the Genocide Convention. So that is the sole basis upon which Ukraine, South Africa and Nicaragua has brought the proceedings. Obviously, we can think about, if we consider the situation with respect to Hamas, Israel, multiple allegations about breaches of various areas of international humanitarian law in particular, that the South Africa-Israel case does not raise that. It only raises questions about violations of the Genocide Convention. All of the cases are, of course, very high profile because they've arisen as a result of conflicts which, even though they're occurring in a regional setting, have attracted global media attention, global interest amongst states in the international community, and obviously, if we reflect upon the actions on the streets of Australia, interest amongst civil society more generally. All three of the cases either have direct or indirect involvement of permanent 5 members of the Security Council. Quite obviously, one of the cases involves the Russian Federation, and we obviously appreciate the fact that the United States is very actively engaged in overseeing, supporting, assisting, advising as a diplomatic ally of Israel. And so to that end, the United States is actively involved, certainly in the cases arising out of the Israeli response to the Hamas attacks on 7th of October. All of the cases involve the International Court having jurisdiction founded on the Genocide Convention. And that's a technical legal issue, but it's a fundamental one, because the International Court of Justice does not have jurisdiction over every dispute that exists between states. So in bringing these proceedings before the court, the applicant state must be able to demonstrate that there is a jurisdictional basis for the court to be able to decide and hear the matter. And because, as I've already indicated, the Genocide Convention provides that basis, it gives to the court compulsory jurisdiction, that jurisdictional basis exists. All of the cases, as I've said, are ones which involve requests for provisional measures. And as a result of that, they're all at very early phases, and we have a long way to go before we see a final resolution of these cases. I would normally tell my students that you'd expect at a minimum 3 to 4 years before cases get determined before the International Court. So we've got some long way to go before we'll see a resolution of these matters. So given that my focus this evening is on these cases and where they're at, it's perhaps important to just briefly reference the test, the standard for when the International Court would seek to issue provisional measures orders, as I described them before to you, effectively a form of international injunction issued by an international court. So the key aspects of the court's test, and this is taken from the Ukraine-Russia case from 2022, is that the court is seeking to preserve the rights claimed by the parties. And obviously the rights claimed by the parties in these cases revolve around issues about whether or not genocide is or is not being committed on the basis of the evidence that is being presented to the court. And the test for determining whether or not provisional measures should be issued are that the claims made by the applicant state, the claims made respectively by Ukraine, South Africa, and Nicaragua are at least plausible. I'll repeat that, are at least plausible. So it's important to emphasise at no stage in these proceedings has any determination been made by the International Court whether or not genocide is or is not being conducted. And so I think we need to be really cautious about claims and statements being made that genocide is being conducted by State A in State B. There's no finding by any international court that that's actually occurred in any of these matters at the moment. But certainly what the court has been asked to determine is whether or not, on the basis of the evidence before it, the claims are at least plausible. Now, ultimately, when the claims go for determination by the court at the merits phase, the court might say, well, look, on the basis of the evidence that ultimately has been presented, we're not really convinced. So just be mindful of that in terms of thinking about the test that the court is applying at this very preliminary phase. So with that background, I'll then just take you through the three cases on a fairly brief basis, make some observations about them, and then move through to my concluding observations. So Ukraine-Russia. This is, it's been described as a reverse genocide case. And that immediately should give you an indication as to why distinctive and how novel this particular case is. So Ukraine-Russia is commenced on the 26th of February, 2022. What's the significance of that date? When did Russia allegedly invade Ukraine? It occurs within 48 hours of the Russian military intervention in Ukraine. So that in itself is extraordinary. The fact that a state who suffered a military intervention is able to go to The Hague and commence international proceedings in the International Court so quickly. The other really distinctive aspect of this case is the number of states who've intervened. You need to be aware of the fact that whilst the statute of the International Court of Justice allows for intervening states, that's respected as a process, up until this case, it has been absolutely exceptional that any state would seek to intervene in a dispute between State A and State B before the International Court of Justice. A prominent example that some of you might be aware of is that in the whaling case between Australia and Japan, New Zealand intervened in that case. It intervened as a state party to the Whaling Convention to make submissions to the International Court effectively in support of the Australian arguments that were being made in the case against Japan. That was novel, that was exceptional. This is absolutely extraordinary. So never before have we seen anything more than one state intervene. The fact that 32 states have intervened in this particular case, as I said, is really quite exceptional. I'll make some observations about that a little later. So what was the basis for Ukraine commencing these proceedings before the International Court of Justice? President Putin, you might recall, had asserted in and around the 24th of February 2022 that the basis for Russia's special military operation in eastern Ukraine was gross violations of human rights amounting to genocide on the part of Ukraine against the citizens of eastern Ukraine. So Ukraine is effectively going to the court and saying there's absolutely no foundation at all for this claim, and even if there was, there is no justification under the Genocide Convention itself to assert that if an act of genocide is occurring, you can then militarily intervene in the affairs of another state to effectively seek to halt a genocide allegedly occurring. And that's why, as I said, this is an example, a novel example, an exceptional example of a so-called reverse genocide case. So the Ukrainian case proceeds on that basis, and Ukraine seeks provisional measures orders from the International Court, effectively saying to the court, well, there's no legal basis at all for this Russian intervention in eastern Ukraine. There's no legal basis at all for this supposed special military operation that Russia is conducting. The court convenes its hearing relatively quickly, and not surprisingly, it comes to a decision that, yes, there is no basis under the Genocide Convention for Russia to militarily intervene. It requires Russia to withdraw militarily from Ukraine. And of course, as we know, Russia refuses to comply with those orders. What has occurred since March 2022, which is when those provisional orders were issued, is that this case has proceeded in the normal course of events onto what ultimately will be a merits phase, where the court will formally adjudge and determine the legitimacy of the Ukrainian case. And it's during that intervening 2-year period that we've seen these 32 states intervene to effectively support the Ukrainian interpretation of the Genocide Convention, including Australia. And so to that end, Australia has an interest in this case as an intervening state. And as we continue to work through the various phases of this case, Australia may well seek to appear before the International Court of Justice in The Hague to make legal argument, I presume, in support of the Ukrainian arguments that the Genocide Convention does not provide a legal basis in any way at all for the purported Russian military intervention. So that's Ukraine-Russia, and it has, as I said, a novel aspect to it, and it has an Australian dimension which is perhaps unexpected. Let's move to South Africa, Israel. I've given you the background to how this case commenced. And of course, here we have a very different type of case. Here we have South Africa going to the International Court of Justice, asserting that Israel's military operations in Gaza are in breach of the Genocide Convention. And to that end, South Africa asserts that there is sufficient evidence of genocidal intent on the part of Israel in terms of political statements made by leading Israeli politicians, and that genocidal intent is backed up by genocidal conduct on the part of the Israeli Defence Force. And so to that end, bear in mind that to be able to ultimately prove a breach of the Genocide Convention, you need to show both genocidal intent and genocidal conduct. That case has proceeded, once again, at a very exceptional level through multiple different phases since it was brought in late December. So South Africa has gone to the court not only in originally commencing these proceedings, alleging breaches of the Genocide Convention by Israel, but they have also at the same time sought provisional measures from the International Court of Justice. And so the court has, on 3 occasions now, issued provisional measures, and on 1 occasion reaffirmed existing provisional measures. So on the 26th of January, we had the first handing down and finding of provisional measures against Israel, which effectively said to Israel, there's sufficient evidence here. There is a South African case which is plausible. I might emphasise again that word plausible. There is a South African case here that is plausible that genocide is occurring. We therefore remind Israel of its obligations under the Genocide Convention not to engage in conduct which could ultimately be determined to be in violation of the Genocide Convention. It makes particular orders with respect to the conduct of the Israeli Defence Force, and it also makes particular orders with respect to humanitarian aid and assistance. Now, those orders are not, I emphasise, they are not directed towards Hamas. They are directed towards the Palestinian civilian population. On the 16th of February, the International Court, again at the request of South Africa, reaffirmed those original 26 January orders. And then we had additional orders issued by the court in relation to the Israeli military operations being conducted in around Ramadan. And then most recently, we've had the 24th of May provisional measures orders which relate to the events concerning the Israeli military operations conducted in Rafah. So can I just once again emphasise to you how exceptional this is? There's never been a case before the International Court of Justice where an applicant state, that is a state who has commenced proceedings, has continually gone back to the court arguing for the extension, for the adjustment, for the modification of original provisional measures orders. And on every occasion, the court has been receptive to that. Now, at one level, that's perhaps understandable given the evolving nature of Israel's military operations in Gaza. So this is not a case where the factual circumstances have stood still as at the 26th of January. They have evolved significantly between the 26th of January and the most recent orders on the 24th of May. So the case is exceptional from that perspective, but it also reflects the evolving nature of the military conduct. I'm happy to answer some questions about the way in which those proceedings have been conducted. It needs to be acknowledged that Israel, to its great credit, unlike Russia did not appear before the International Court when Ukraine originally sought provisional measures against the Russian Federation in February, March 2022. Israel has attended and participated very actively in all of the proceedings to date. So let me come to the third of these cases, perhaps the lowest profile of the cases, and that is a case between Nicaragua and Germany. also alleging breaches of the Genocide Convention. So we are all very mindful now of the symbolism of the way in which the Genocide Convention is now being used against two states who many of us would associate with their backstory and their background in terms of the way in which the Genocide Convention was negotiated post-World War II. This case is quite different from the other cases, and really what Nicaragua is alleging is that Nicaragua, as a party to the Genocide Convention, is asserting that Germany's conduct in terms of its military support for Israel and Germany's conduct in terms of suspending aid to UNRWA, the UN aid agency that operates in the occupied Palestinian territories and, of course, very prominently operates within Gaza, that Germany's conduct in that regard is also in breach of the Genocide Convention. Provisional measures were sought before the court in April 24, and those provisional measures were declined by the court in April, basically because the court took the view that there was no sufficient basis for it to order provisional measures in this instance. It did find that it had jurisdiction, once again, because the case was brought under the Genocide Convention, but it found that there was no urgency with respect to the case, that there was no evidence of irreparable harm being possibly conducted. And Germany put up a very robust defence in terms of these proceedings, which needs to be acknowledged. And in fact, Germany asked that the court discontinue these proceedings. The court declined to discontinue the case. But where this case goes at the moment is somewhat uncertain, given the failure of Nicaragua to have these orders issued, at least at this preliminary phase. So I've sought to give you an overview of these three extraordinary, exceptional genocide cases and the way in which they proceeded before the International Court over the course, literally, of the past few months. So let me try to make some summations in terms of concluding observations and comments, which can hopefully then become the basis for our discussion. Quite clearly, the International Court of Justice has become a focus for unprecedented international attention framed around the Genocide Convention between late December 2023 right up until now. And so to that end, the spotlight has been placed on the International Court of Justice in ways that I cannot recall throughout my career as an international lawyer. We can have discussions as to whether or not that's necessarily a good or bad thing. Secondly, all of the cases rely upon the court having jurisdiction framed around the Genocide Convention. You need to appreciate that in every case that is brought before the International Court of Justice, the first question that's always asked is, does the court have jurisdiction? We need to recall that these are not disputes that are occurring before, say, the Supreme Court of Queensland, where the Supreme Court's jurisdiction will really rarely be questioned. Jurisdictional foundations before the International Court of Justice are always contested. But in these cases, they are very firm, and it's unlikely that the court will decline saying that it doesn't have jurisdiction because of that pivotal provision that's founded within the Genocide Convention that I spoke about previously. The other exceptional aspect of these cases, other than Ukraine, Russia, is the standing of the applicant. What's South Africa's interest in bringing a case against Israel, you might ask?
Yes.
Likewise, what is Nicaragua's interest in bringing a case against Germany? And this triggers what international lawyers call obligations erga omnes, or obligations erga omnes parties. The extent of the interest is because South Africa and Nicaragua are parties to the Genocide Convention. And as a party to the Genocide Convention, it's arguable, and obviously the court has been prepared to accept that argument, at this preliminary phase, that those states have an interest in ensuring the prevention of genocide. And if they see breaches of the Genocide Convention, they therefore have standing to go into the International Court and to seek to enforce the Genocide Convention against Israel and Nicaragua, respectively. And that's exactly the same basis upon which the Gambia has brought its case against Myanmar, I spoke about previously. So that is a really interesting development and ways in which we might see other states begin to think about the standing and the capacity that they could have to bring international proceedings. As I've spoken about, all of the cases involve provisional measures. The other interesting aspect of the case is the number of interventions. I spoke about the number of interventions in the Ukraine case involving Australia. That number of interventions is up to 32. At the moment, formally, there are 5 interventions in the South Africa-Israel case, but there are 8 other states which have indicated publicly, including Spain just last week, that they are seeking to intervene. So we might be up to something like 13 interventions in the South Africa-Israel case. The South Africa-Israel case interventions might raise some really fascinating questions as to which side those intervening states might sit. It's also not only raised the global profile of the International Court of Justice, it's also raised the workload of the International Court of Justice. The ICJ has 15 judges, including our own Judge Hilary Charlesworth, the Australian judge who's been re-elected to the court as of late 2023. But in reality, the International Court has been as busy, if not busier, than the High Court of Australia in terms of its workload at the moment. This is really an exceptional time for the International Court under the global spotlight, with perhaps a raised expectation as to what the International Court might be capable of bringing about some resolution in terms of these important cases. And I guess ultimately, Chair, my final observation is that this has raised debates about the merits or otherwise of lawfare. Is this an example of states using international courts as a way of promoting, advancing a foreign policy objective? Is there a legitimacy in the way in which some of these states have brought these proceedings in the International Court of Justice? Is it appropriate to use the International Court of Justice perhaps as a political forum rather than a legal forum? That's a sort of lawfare argument that's made. The alternative argument is, well, actually, is this really a form of global justice? Is this really an effort by states to hold those who are alleged? And it's important to emphasise that these are only allegations at the moment, that these are allegations against states which that they have committed acts of genocide, or in the Ukraine-Russia case, there is no evidence of genocide. Is this really a case of states actively utilising international legal mechanisms to bring about resolutions of disputes? Colleagues, quite clearly, this is an evolving story. Just within the last 24 hours, of course, we've had a UN Security Council resolution adopted, remarkably by 14 votes to 0, no veto exercised. A Security Council resolution advanced and promoted by the United States calling for a ceasefire in Gaza. So we're at a very pivotal moment in terms of how that aspect of the proceedings might commence. I guess one reassuring reflection is that we now actually have some parallel developments occurring both within the International Court and also within the United Nations Security Council, 2 of the prominent organs of the United Nations system, at least focused on the situation in Gaza. I look forward to questions, Chair.
We have a few questions online, but before we throw to them, do we have any questions from the audience? Yes, starting here.
Yeah, thanks for speaking, Chloe. Just as Benjamin Netanyahu has said, nothing is going to stop us, not even the Hague. Is it possible if the ICJ finds Israel guilty of violating the Genocide Convention, they might just ignore it? Is that a possibility at all?
Well, I think when we think about that scenario, we need to think about the temporal dimensions. So even if the court was to make that sort of ruling or determination, we are probably 4 or 5 years away from that. Remember the timelines that I identified in the Bosnian genocide case, and there's all sorts of legal procedural issues that can be thrown up before the court would even reach that sort of finding. And if I can say, even acknowledging the political longevity of Benjamin Netanyahu, he may not be in office by the time we get that sort of judgment out of the court. What perhaps is more significant is, of course, a completely separate issue, Chair, that I'm not discussing this evening, and that is, of course, a potential ICC arrest warrant against Prime Minister Netanyahu and his colleagues, and also, of course, significant Hamas leaders. So that level of international accountability, which is a parallel process, will probably proceed more quickly than some of these ICJ cases I've been speaking about this evening.
Yes, gentleman in the middle. Yes.
Yes, good evening. Two-pronged question on your points about the short time frame of 2 days between the military operation and the presentation in the court. Does this in any way suggest that there may have been a dialogue between the two countries and that Ukraine was prepared for this all along? There was some sort of ultimatum given, perhaps echoing that of the no further bases to the east expansion. And secondly, the Putins refusal to appear. What do you think, in your opinion, or do you know of any statements he's made to explain why he didn't go in?
Thank you for that question. I guess in terms of the rapid nature of Ukraine commencing its case in the International Court, if we recall the events of January and February 2022, I think Russia's military objectives were fairly well telegraphed. So that there was a strong expectation that there would be some Russian military intervention in eastern Ukraine at that point in time. And so to that end, no doubt there was a lot of consideration given as to how Ukraine might be able to respond. In addition to its military response, they would have known that any efforts within the Security Council would have been blocked by Russian veto. They therefore no doubt explored this ICJ option, no doubt with assistance from friends outside of Ukraine. Secondly, it's not exceptional that a P5 member does not appear in the International Court of Justice in response to applications that have been brought against them. So I can think of cases in which not only Russia, but also the United States have refused to appear in proceedings brought against them. Of course, China refused to appear in the South China Sea arbitration. So it's not exceptional that P5 members refuse to appear when they're brought before the International Court. Having said that, it does need to be acknowledged that while Russia didn't appear in the initial phase of the case, they did appear in the jurisdictional phase of the case. And can I just share with you, rather remarkably, Chair, I was asked to act on behalf of the Russian Federation, but I had to decline because I told them that I was subject to Russian sanctions. It wouldn't be appropriate to appear given the sanctions that I was subject to.
Thank you, Professor, for this talk tonight. Could you comment on the enforceability of, firstly, the interventions of the ICJ during that phase, and also enforceability of determinations in 4, 5 or more years' time?
Yes, thank you. Well, there's something of an ambiguity in terms of the statute of the International Court of Justice makes it quite clear that the judgments of the court can be subject to enforcement by the United Nations Security Council. But we need to make a distinction between a judgment of the court as opposed to the orders of the court. And so what we've seen to date are just orders being issued by the court as opposed to judgments. So the media, perhaps quite understandably, have latched on to this weakness in terms of the way in which the International Court of Justice can operate. Now, that doesn't mean to say that the Security Council cannot separately take note of orders issued by the International Court of Justice, and I would suggest to you that they clearly have in terms of some of the language that's been attempted in some of the Security Council resolutions. So it is possible that provisional measures orders could be subject to Security Council resolutions. But once again, we then get into the dynamic of the P5 and the way in which the veto may or may not be exercised. But in terms of a final judgment issued by the court, it is possible for the Security Council to enforce decisions of the International Court, but we've yet to actually see any decision being made to that end to date.
There's a question here, lady in the red.
Yes, thank you. You said that the court found that there is no basis for Russia to claim justification for invasion of Eastern Ukraine on grounds of genocide. But because the case is ongoing, does this mean that there has not yet been a finding that there is no genocide? Is that the correct understanding?
Yes, correct.
So
So we really have a completely neutral determination made in terms of, well, whether or not genocide has or has not occurred in Ukraine or in Gaza to date.
Yeah.
It's just that the cases are radically different. Ukraine, Russia is really saying, well, on a preliminary basis, on the evidence presented before the court and on the interpretation of the Genocide Convention, there is no basis, as far as the court can see, for Russia's military intervention into Ukraine.
Mr. Forrest.
Yeah, I'm reading out from the online questions.
Very good.
So, and there's two questions that really ask the same thing. And interestingly, one's from Johannes and one's from Louise Müller. So they're asking about the Nicaraguan case against Germany. And I respectfully acknowledge that this is not really a legal question and asking you a matter of legal expertise, but they seem to both want to know the motivation. If you have any idea of Nicaragua's motivation for targeting Germany in particular, having regard to the fact that there are other countries that support Israel militarily, and even Louise points out other EU countries that probably more so than Germany does, and they're just wondering if you have any idea about that.
I cannot offer any insight into that, and I can state that an Australian international lawyer with vastly more experience before the International Court of Justice than what I have is also equally mystified as to why Nicaragua has succeeded. Having said that, you might be surprised to learn that Nicaragua has been involved in as many cases before the International Court of Justice as both the United Kingdom and France. So it is not a stranger to the International Court of Justice and has been a very active litigant and also respondent in cases before the court. Having said that, in terms of that background, this is an extension of Nicaragua's engagement with the court in these types of matters. Most of the cases that Nicaragua has been involved with are all concerning its Latin American neighbours.
They've been a responsible litigant? How do I follow up?
I think they have, yes.
Gentleman in the green jumper.
Thank you. Sean, absolutely. My name's Eugene. Well, my question here is, you skirted the ICC activities. And my question to you is this: the expert panel with respect to the charges which may ultimately be brought against Netanyahu and Gallant, surely that will give evidence of intent for the purposes of the ICJ. Wouldn't that speed up the process of the ICJ hearing?
Yeah, thank you for that question. And I guess this is an issue that international lawyers have now begun to speculate about, because you're right that evidence that might be used by the ICC prosecutor in terms of any cases that might be brought against Netanyahu and Gallant would also be the identical type of evidence that might be relied upon by South Africa in the case before the International Court of Justice. But as I've said, the two cases will probably proceed on different timelines. And so to that end, it'll be really fascinating to see ultimately what referencing the ICJ might make to those separate ICC proceedings. But I agree with you that at a core, the evidence, the foundational evidence will not be that dissimilar in terms of the conduct and the statements made by the Israeli political leadership in terms of evidence of genocidal intent.
There's a question, yes.
Thank you, Professor. I wonder if you'd be kind enough to give us a definition of what sort of behaviour constitutes genocide.
Thank you. So the Genocide Convention in Article 2 talks about conduct on the part of a state, and this is important. We're not talking about conduct on the part of individuals. Conduct on the part of a state which is directed towards a civilian population which might seek to eliminate or severely impair that civilian population. And to that end, it can extend to widespread murder, it can extend to starvation, it can extend to experimentation on that civilian population, and it can also extend to conduct which is directed towards the children of that civilian population. And so it's fairly broad, but nevertheless, the evidentiary threshold that needs to be met in terms of any of these cases, both in terms of genocidal intent and genocidal conduct, is very high. And so we need to be mindful of that. And so at the moment, these cases are all at a preliminary stage, and so the evidence is all very preliminary. We'll need to see how those cases proceed in terms of the ultimate evidence that might be presented before the International Court of Justice to be able to determine the strength of those claims.
Gentlemen?
Yeah. Professor, it seems a bit rich, doesn't it, that the matters haven't even been settled. You said that the main evidence has not been presented to decide, for the courts to decide on the issue of genocide. And on the basis that you just told the gentleman, genocide is a very, very wide definition. It could actually be made out law. Okay. So first part of the question is, how can they then issue an arrest warrant against Netanyahu or even Putin when the matter hasn't even been decided? That's the first part. The second thing issues that we all talk about this thing as if it's a fait accompli. The conduct of NATO and the USA in Ukraine before the Orange Revolution, bringing about that situation, so despicable as to bring about the war, the special military operation. So this matter is very, very up in the air. And so I wonder for you to comment, don't you think the International Court of Justice is sort of leaning over its skis here?
Yeah, look, I readily admit in terms of the second part of your question that the ICJ has been thrust into the middle of a very significant political maelstrom, certainly in terms of Ukraine, Russia. And the court's role in Ukraine, Russia is really very narrowly defined. It's quite a different role to the way in which we might see its role in terms of the Gaza conflict. It's really seeking to ultimately reaffirm the justification for Ukraine saying there was no basis at all under the Genocide Convention for the military intervention on the part of Russia. In terms of other political or legal accountability, the court at the moment doesn't have a role in that process. So its role is very narrow, its role is very limited, and ultimately its role is one which seeks to provide a further sort of political justification or foundation for the righteousness, if you like, of the Ukrainian position, I think, in terms of the Russian military intervention. In terms of the other matters, I think we really need to be really careful about distinguishing between the separate cases being brought against a state and the separate cases that may be brought against the political leadership in Israel and also the members of Hamas. And to that end, we're looking at completely different legal processes. We're looking at completely different courts. There is perhaps an understandable process in which the two are merged, and there's some confusion arising around that. I find myself constantly correcting journalists who make errors between the International Court of Justice and the International Criminal Court. I guess from my perspective, I celebrate the fact that these courts and these processes are being used, but there will inevitably be some crossovers and tensions arising from that. And perhaps the really unique moment that we're at in terms of international law is that both of these processes are being used simultaneously, in parallel and in tandem. And in answer to the other question, the evidentiary issues will in fact blend and meld with each other.
Oh yes, sorry, there was a question.
Yes, the purpose of the convention is to prevent and punish. So how does the punishment side work out? Is it just through the UN Security Council, or are there other channels?
Yeah, thank you. Thank you for that question. So here, Chair, I might just answer by reflecting upon Australia's role in the Genocide Convention. If any of you are interested in doing some history and some research on Australia's role in the Genocide Convention, the Genocide Convention was concluded in 1948. And at the time, there was actually a rather remarkable debate that occurred in the House of Representatives to enact the Genocide Convention Act. That was absolutely extraordinary at the time, because there was no process or mechanism whereby the Parliament would be required to debate Australia becoming a party to a convention, which is quite different to the processes that we see today. However, notwithstanding the enormous merit of the actions taken by our Parliament, they did nothing about it other than pass the legislation. In other words, following that, the crime of genocide did not exist under Australian law. And so it wasn't until Australia became a party to the Rome Statute in the early 2000s that we saw the International Criminal Court Act and amendments to the Commonwealth Criminal Code, which actually made genocide a crime under Australian law. And so in direct answer to your question, the expectation and the obligation of state parties to the Genocide Convention is that they will prosecute persons who have committed genocide within their territory, or nationals who have committed genocide in other places. And so the primary expectation is that your own domestic, your own national law will create the crime of genocide, and prosecutions will occur in that forum. Now, that has rarely occurred, because obviously any prosecution of a crime of genocide at a domestic level is a very political prosecution, which inevitably will raise very significant political tensions. And there's been no example that I can think of where any Australian in modern times has been alleged to have committed an act of genocide. We, of course, have parallel and separate processes in terms of war crimes trials at the moment. So in terms of decisions for the International Court of Justice and ultimately determining whether or not breaches of genocide will occur, well, ultimately a finding by the court would be that, yes, there has been a breach of the convention, and the court would then have open to it the ability to issue various orders associated with the extent of the acts of genocide that the court determines on the basis of the facts before it. But on the basis of what I've told you in the history, these are truly exceptional cases, and we don't necessarily have, in terms of states being found to have committed genocide, a lot of track record or history in relation to that matter, as opposed to international criminal proceedings against individuals who have been found guilty of acts of genocide, and we've certainly got examples of that arising out of the Yugoslav and the Rwandan conflict.
As a cognizant of the time and that you've been answering a lot of questions, can I ask you one question from myself, please? I imagine the nature of genocide litigation for the ICJ, the final relief that parties are seeking are State B cease engaging in acts of genocide. You mentioned before that provisional measures, applications for provisional measures are rare. In the three cases you've discussed, two of the cases provisional measures have been ordered, but interestingly, in the Nicaragua and Germany case, it has been declined. Now, you've mentioned that the threshold test is a plausible allegation, so I'm butchering that a little bit. Given that what seems to be a pretty low threshold, in a case such as Nicaragua, where the court has declined to make a provisional measure, does that somehow speak or give an indication of where the court is going ultimately with the final application?
Yes.
Okay.
Yes. Certainly, if you read the orders that the court issued back in April, it certainly raised questions, I think, about the strength of the Nicaraguan case. And as I said, Germany requested that the court remove the case from the list. The court declined to do so. And I think to that end, certainly the cases arising out of the situation in Gaza, as we know, are very dynamic. They're effectively changing every 24 hours. And so to that end, I think the court would have been mindful of the fact that there may well have been evolving circumstances under which the original application brought by Nicaragua could, over a period of time, change. And just like the Israel case that South Africa has brought, there may well be a basis upon which Nicaragua would go back to the court saying, look, actually, the circumstances have changed. We ask you to revisit your original orders.
So it doesn't necessarily indicate that Nicaragua will withdraw their case, but it might, as circumstances change, find a way to evolve.
Correct.
All right. Ladies and gentlemen, thank you again for joining us this evening. I will invite you to thank Professor Rothwell.
Yes.
Over to Ben, who will tell you all about our upcoming events.
Just some housekeeping, guys. We've got a full lid in the upcoming months. We've got one other event in June on the 25th, which will be our trivia night hosted by our interns. So feel free to come along to that. There'll be some prizes available for the winners. We've got a full lid in July, 4 events. On the 4th of July, we've had the New Colombo Plan Scholarship. We have some alumni and scholars in attendance. A must attended for students in the audience tonight. On the 9th, we've got Professor Ian Hall from Griffith University, who will speak on the upcoming Indian election and what it will mean for the Indo-Pacific. On the 23rd, we have Dr. Connie Karugan from Griffith University, who will speak on global partnerships for local and regenerative climate actions. And lastly, on the 30th of July, we have Associate Professor Scott Waldron from the University of Queensland, I believe, who will speak on the third-party plenum, China's economic trajectory and what it all means for Australia. So if you're not already a member, please consider subscribing, and thank you very much for attending.